Good morning everyone, good morning sir. My name is Maricel Similar, and for this video I tackle about the scientific evidence in chapter 4 and the subject forensic chemistry and toxicology. So let's start. In chapter 4 we have tackled about the evidence, types of evidence, and in related in scientific evidence. So first we have tackled about evidence. This is the evidence. Evidence is a proof of allegation. It is a means sanctioned by a law of ascertaining in a judicial proceeding the truth respecting of matter of fact. In section Rule 128 revised rules on evidence. Evidence is an allegation that means sanctioned by law or ascertaining in judicial proceeding the truth respecting a matter of fact. It means that evidence is a proof that used in judicial law sanction or used against criminal actors or criminal or what do we call a suspect of the crime scene as the truth respecting of matter of fact. That is evidence. In evidence we have in corollary thereto, scientific evidence may be defined as a means sanctioned by law of ascertaining in judicial proceeding the truth respecting of matter of fact, where scientific knowledge is necessary. Such scientific evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. And corollary, scientific evidence as defined as what is the scientific evidence definitions. It means it is a sanction by law, it is ascertaining in judicial proceeding the truth respecting a matters of fact, and it is such as scientific evidence must have an relation to the fact in issue or including belief in its existence or non-existence. An example of this in evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. There are evidence in collateral matters shall not be allowed. The evidence is not allowed except when it tends in any reasonable degree to establish the probability or improbability of fact in issue. The evidence shall not be allowed if the reasonable degree establish the probability or improbability not not connect in the issues. So that is evidence on collateral matters. Next, we have the evidence, types of evidence. Evidence may be, first we have A, direct. Second, we have indirect, which includes circumstantial evidence, and C, we have the hearsay. I repeat, evidence may be first direct, second indirect, which includes circumstantial evidence, and third we have hearsay evidence. So let's go to direct evidence. So first, direct evidence is that which the senses perceive any fact to which a witness testifies based on what he saw, heard, smelled, touched, or tasted is direct. So direct evidence is based on the senses of people or what is he or she going to heard, smell, touch, or tasted is directed. Let's see the pictures in my presentation. That is the example of direct evidence. If the gun can touch by the suspect or or the witnesses, um, and if you heard something, example, if you heard something, scream like they need help because that person commit that crime on her, or you smelled, um you smelled, um think you smelled stinky, or you touch that that victim, or you tasted that, example of tasted is the if it is the illegal drugs like that. So that is direct evidence. Let's see the pictures. That is the example of direct evidence. Next, we have the example of scenario is like this. Example of scenario: crimes are done secretly. Usually, the perpetrator seeks darkness and remoteness in order to cover his misdeed, and in most cases, no witnesses is present at the scene of the crime, or even if there is a witnesses, he or they are not going to willing to testify. He necessity of resorting to other means of proof is essential, hence it is necessary to use all other available modes of procuring evidence in order to establish and prove in case in court. Direct evidence cannot be cannot be cannot be seek I mean scientific evidence, means direct evidence are um, more on resolving a crime, examine a crime, and test test a crime, or they need a testify to make that evidence, um, to make that evidence, what do we call this, to make that evidence approved by the court. So if you have that direct evidence, you are going to seek others other needs for, or other witnesses to present in that scene to to witness what he or she going to smell, talk, or etc. That types of direct evidence. So that is direct evidence. Next, we have circumstantial evidence. Circumstantial evidence is a kind of evidence which seek to establish a conclusion by interference for the facts proven. This circumstantial evidence is what we are going to call the witness evidence, because it seeks to establish a conclusion by interference from the facts proven. They seek, um, witnesses testimony, or a person, or they 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 locate the fingerprints or the other evidence that they going to present in the court. Example of circumstantial evidence: first, we have the eyewitness testimony that the person was seen fleeing to the from the scene of the crime. Again, eyewitness testimony that the person was seen fleeing from the scene of the crime. Eyewitness, they use the um, seeing testimony to the person, um, person person see that the person was fleeing from that scene of the crime. So that is the first example. Second example, we have a person's fingerprint found at the case of the crime alongside other people's fingerprints. Circumstantial evidence, it depends on the situation. If a person if a person fingerprints found on the scene, or they have other people's fingerprint, they going to seek or to test that who are the who is or who are the suspect of that crime scene. So that is the second. Third, we have an audio recording of a defendant stating his or her intent to commit a crime before the alleged crime actually occurred. The third example is based on what is the defendant stating or intent to commit the crime before they allege the crime actually occurred. That number samo kayo. That number three example are based on the statement of the of, statement of the statement of the suspect for her intent to commit crime before the alleged crime occurred. Next, we have the illustrative case. Illustrative case, when a policeman was patrolling, he heard a scream from a house. He immediately proceeded to the house, and then he saw a man coming out of the house carrying a bloody knife. The policeman arrested the man and subsequently entered the house. There he is saw a female cadaver lying on the floor with a stab wound on the breast. In this case, the only direct evidence is which the policeman case testify would be to the fact that he saw a man with a bloody knife. That is the direct evidence. You actual seen the crime in that one place. Coming out with a bloody knife, coming out of the house where the scream came from, where the victim scream, the suspect is on that house. So next, the prosecutor may be establish a conclusion that the man with a bloody knife and the circumstantial evidence on this is the fingerprint on the bloody knife. If the suspect is really the who commit the crimes on the girl in her house, is the criminal by interference from the fact to facts testified by the policeman. So the policeman is the one who testified that suspect who carried the bloody knife coming out from the house of the girl where the scream came from. The prosecutor may be established, so that policeman testified that that suspect is really the criminal or the one stabbed that girl. So next, we have the under present law, circumstantial evidence is sufficient for conviction. First, there is no more than one circumstances. they have no other more than one circumstances. That is the first under the present law circumstantial evidence is sufficient for conviction. Second, the facts from which the interference are derived and proven. If the fact are proven or the interference are derived are proven, that is the second. Third, we have the combination of all circumstances is such as to to produce conviction beyond reasonable doubt. That is the present law circumstantial evidence is sufficient for conviction. The next evidence we have the hearsay evidence. Hearsay evidence is a statement made by a witness on authority of another and not from his own personal knowledge of observation. Hearsay evidence is the one who witnesses from what he's going to know about that crime scene, or he or she actually seen that crime scene and who are the suspect on that crime scene. Hearsay evidence is inadmissible except of the following. Inadmissible except of the following. Example. We have where a person A sees someone climbing into the window of a house. A later tells person B that the person he saw was C. Evidence. Evidence from B of what A told him is a hearsay, because he testifies that but that C was the one who climbing into a window of his house, because A was testifying in what he know and what he are going to what he have seen. So if A give his account in a witness statement to the police, the statement itself would be hearsay. So if A was stated to the what if A was witnesses stated in the police, the statement itself would be hearsay. So that is hearsay. Next, we have what is considered hearsay evidence. So next, the question is what is considered hearsay evidence. Broadly defined, hearsay is testimony or documents quoting people who are not present in court. When the person being quoted is not present, establishing credibility becomes impossible. As those cross-examination, as such, hearsay is evidence inadmissible. Hearsay is also testimony or witnesses or documents quoting people that is hearsay. Hearsay. So that is to consider hearsay in evidence. So next, hearsay evidence is admissible except on the following. First, we have dying declaration. If you declare the one who died, that is inadmissible of the hearsay evidence. So next, we have res gestae, declaration against interest. If you declared against to have an interest about that person, that is inadmissible on hearsay evidence. Act or declaration about pedigree, family reputation or tradition regarding pedigree, common reputation, part of res gestae, interest in the course of business. If you are if you are witnesses for your interest of the course of business, that is admissible in the hearsay evidence. Interest in official records, learned treatise, and testimony of disposition to a former proceeding. So that are the inadmissible exemption on hearsay evidence. So next we have forms of scientific evidence. First we have unreal autoptic evidence. Real or autoptic evidence is that evidence which is addressed to the senses of the court. It is not limited to that which can be known by the sense of vision, but extend to those which are perceived by the senses of hearing, taste, smell, or touch. Real or autoptic evidence was similar on direct evidence. Example of real or autoptic evidence is fingerprints, blood samples, DNA, a knife, a gun, or other physical objects. Real or autoptic evidence was similar on the direct evidence because he it perceived by the senses of hearing, smell, taste, or touch. That that are the 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 ability or in the direct evidence, so they are similar. Next we have an testimonial evidence. Testimonial evidence are may be called on the witness stands to answer all questions propounded by both parties in the case. Testimonial evidence are the one who witnesses or the one who stands to answer all the questions of the both parties in the case. Example of this is if someone the example of the testimonial evidence if the two if the two friends were going home and then the one friend stabbed by the person or by the unidentified person, the second friend was the witnesses to stand to answer all the questions what is going to give on him. That is the testimonial evidence. So again, testimonial evidence is all about the witnesses who or witnesses he or she stands to answer all the questions propounded by both parties. Kailang it it may it very important to answer all the questions that giving on him or her to the both parties in the case. So example, witness pointing to someone in the courtroom and saying, "That's the guy I saw robbing the grocery." So that is the example. If he or she really know what is the who is the suspect, he or she pointing to someone on the court and saying that that guys I saw that guys is suspect on that robbing or any kind of criminal act. So next, that is testimonial evidence. So next we have the documentary evidence. Documentary evidence is any written evidence presented by an expert in court which is relevant to the subject matter in dispute and not excluded by the rules of court. Formal written report, expert opinion, certificates, and dispositions are included in the group. Documentary evidence is what we call the paper evidence. It presented by expert in court, like the the one who studied the crime scene, the investigator, the policeman, or even the doctor, because DNA, or the example of that is DNA on the giving reports or certificates that that person was the one who committed that crime, and that is included in the group. Example of this is an accused is charged with making a false report. The government, to prove its case, would want to introduce the report in evidence. Another example could be when a service member is absent from his or her command. To prove that he or she was absent, the government would introduce an entry from the accused service record as proof of his fact. First, so that is documentary evidence. If that person is absent, they going to say to they going to present some important evidence like record or etc. So next we have the investigator. The investigator is the fact of finder. It is basic that he must know the laws concerning the nature of his investigation. He should procure evidence in such a way that his findings can be admitted in court and remain impregnable against any attack by the opening counsel. He should be in constant contact with various investigative and enforcement agency. Investigator is the one who investigate the crime scene, or what do we call that, studying or examine the crime scene for gaining the fact that he or she present on the court, and to prove that that person or that victim or that suspect was truly a victim or a suspect on that crime. The investigator also may be policeman, um, the detectives, or even government employers, or even you, if you investigate the crime and you gathered information to present in the court and give the real scenarios on the crime scene, you are also a investigator. Next, so that is all for this report. My understanding about this scientific evidence, it says it is very important to know or to learn, because it will help us in future as a future policeman or anything that you want based in your courses. It may help you to solve that crime, to fast locating that criminal person, or to locate who is the truly victim, or who is the suspect. And also the types of evidence that you gathered, the types of, and what are the important things that you do if you are going to investigate crime scene. And even if you are um, uh, making a report, like you study the crime against that, or a robbery or something, it will help you to to locate, or to solve that perfectly. That is the scientific evidence. So that is all for today, and for the thank you for the thank you for watching. And all of this is my my all of this is my work. And then thank you, sir, and thank you all, and God bless. So our next topic, we have a witness. So witness, that is chapter 5 in forensic for chemistry and toxicology. So witness defined: a witness in court may be an ordinary or expert witness, a person who sees an event, typically a crime or accident, take place. Witness is a person who sees the actual event or the exact phenomenon in a crime or accident in one place. That is considered a witness. That person is considered a witness. Witness also are like an testifying evidence, because witness carry the the evidence of an exact evidence, because of his actually participant on that event or that crime. So that is witness. Witness under the law, an ordinary witness must have the following qualifications. He must the he must have first we have the he must have the organ and power to perceive. So if they if the person gives some statement, he or she must have an power to perceive, to explain that that statement is true. So next, second, perceiving can make known his perception to others. If you exact tells the story that that person are the real criminals, it perceive you to make your perceptions in others. So that is the second. Third, we have the he does not fall in any of the exception provided by law. If the person are not telling the truth, he or she not exempt for provided by law. 1, 2, 3 rule of court. So that is the under law. An ordinary witness must have the following qualification. That is the qualifications. So next, we have this opinion of a witness regarding questions of science, art, trade, where he is skilled therein, may be received in evidence. If the opinions of witness regarding a questions of science, art or trade, etc., he or she is skilled there, and he may be received in evidence. that person will also become an evidence to prove that he or she says an event actually. So next, this kind of evidence is called the testimony of an expert witness. So if the person are regarding answering the questions of science, art, trade, or he or she is skilled therein, and maybe receive an evidence, this kind of evidence is called testimony of an expert witness. So next we have the distinction between an ordinary and an expert witness. First, we have the ordinary witness. Ordinary witness can only state what his sins have perceived. Ordinary witness is based on his senses that he or she sees that event, heard that event, or smell, touch that event, to only perceive for the the truthness of his statement. Second, may we not be skilled on the line of he or she is testifying. Um, Number two, the persons is not be skilled on telling the truth or testifying in crimes or in the court. Third, we have the cannot testifies on things or fact he has not perceived except those provided for by law. If he or she cannot testifies on one thing or on a fact, he or she has not perceived except on those provided for by law. That is the ordinary witness. In expert witness, we have first state what he has perceived and also give his opinion, deduction, or conclusion to his perception. If the person give his perceive his knowledge about that actual incident or event, he also give his opinion, deduction, or conclusion that that exact event or the phenomenon that where is crime committed. So he or she giving his opinion, deduction, or conclusion to this. And second, we have must be skilled in art, science, or trade. He is testifying. He or the person in must be skilled when it comes in art. Example, if the court asking the witnesses who are the um, exact suspect, or can you tell us what kinds of persons that suspect are. So the person must be skilled in art, science, or trade when he is testifying. So third, we have the testifies on things when by which he has not seen, but by giving his opinions, deductions, or conclusion on a statement of facts. If the person testifies in expert witness, if someone testifies on things which he has not seen and giving his opinions, um, even if the persons can don't know what is that thing, he or she must giving opinions, deductions, and conclusions on the statements of facts. So that is the distinctions between an ordinary and an expert witness. So next we have an ordinary witness, or an ordinary witness is the opinion of a witness for which proper basis is given, may be perceived in evidence regarding first identity of a person about whom he has indicate knowledge. B. We have an her handwriting with which he has sufficient familiarity. Ordinary witness is just like an evidence um, the evidence that gathered in a crime scene that he or she identify about what is the or who are the persons under that crime or under that who committed that crime, who suspect committed that crime. That is the ordinary witness. So expert witness is a person who is permitted to testify at a trial because of special knowledge of proficiency in a particular field that is relevant to the case. So expert witness, a person who is permitted to testify in trials because he has the knowledge to participate in that trial and proficiency particular in field in the relevant of the case. So if the persons are have an special knowledge like they they know who are and they know what kind of persons committed on that crime scenes, he or she was permitted to testify at the trials. So that is expert witness. Expert witness. So next we have an example of expert witness. Example of expert witness where renowned expert witnesses includes doctors, psychologists, psychiatrists, social works, and others professionals who are instructed to give experts' opinions in legal proceeding. Example of expert witness in a case is when someone has raped by person, then the families of the victim are going to the doctors for some DNA test or some medical certificate to be produced or to be submitted on trial. So that is expert witness. Example of ordinary witnesses. An ordinary witness can be the police officer who made the arrest of or a person who was the scene of the crime. So ordinary witness is who is the witnesses is the witness who are in the crime scene or who are in the event or who sees the event, who actually sees the event and who are an even police officer that made the arrest of a person. That is an example of ordinary witness. So next we have the difference between ordinary witness and expert witness. An expert witness gives evidence of his opinion. That is expert witness. People give expert witness give his evidence of his opinion. They they come up evidence with his or her opinion. So next, an ordinary witness is a witness of facts and gives evidence of those facts which are under inquiry. So if someone witnessed that event and that person give his evidence like facts which are under inquiry. So that is the difference between ordinary witness and expert witness. Next, we have the probative values of expert testimony. Whether courts are or are not bound by testimony or an expert depends on the natures of the subject of inquiry. It's the subject of inquiry comes within the general knowledge and of the judge, and the latter will not be bound by conclusions of the experts. For instance, when the subjects of inquiry is genuineness of a handwriting as compared to the standard, that is the probative expert testimony when it comes in court. Next, we have, however, when the subject of inquiry is such a nature that a layman can have no knowledge thereof, as for instance, the determinations of parentage through DNA or diacarbonolic acid test. Diaro- Diarubonolic acid test. The court must depend on the result of the examination. Example of this if rape, if rape and and what do we call this? Example is um the qualifications of an expert witness. So first, the degree of learning of the witness. If if you have the degree of learning of the witness, that is very that is that person saying the truth of because of that. So next we have the basis and logic of his conclusion. Persons who bases in his logic of his conclusions, um, he or she straight to the point of giving some testimonies or evidence and see the other proof of his case. So if the persons who testifies or who witnesses that crimes and he or she give another proof for that case, that is one of the qualification of the expert witness. So that is all for today, and I hope you have learned about my topic about witnesses. So thank you, sir. Thank you for the reporting. God bless.